Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. Yeah. Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. Yeah.
All right, y'all. Welcome back to another video. Welcome in. Have a seat. We are here to get into some court updates. Now, we're here to have a conversation about the newly dropped court update regarding Megan Pete versus Milagro Elizabeth Cooper. Now, this was a document that was dropped this morning by Judge Cecilia Altonaga. Now, she is going to get into the order providing instructions for jury trial. All right. Now, before we actually get started, let's make sure we put up our copyright disclaimer under Section 107, just simply saying that, hey, this is fair use. I am not a paralegal. I am not an attorney, and I am also not a judge. Just simply saying that, hey, I know how to read. All right. And without further ado, let's go ahead and get into this actual court document. Again, this is the order providing instructions for jury trial. All right. Now, let's get into the actual detail. Okay. So this is the evidentiary matters in preparation for the jury trial scheduled to commence during the 2-week trial period beginning on November the 17th of 2025, which is approaching soon. Counsel shall meet and prepare an exhibit notebook consisting of 3 divisions. The first division shall contain the parties' joint exhibits. The second division shall contain plaintiff's exhibits. And the third division shall contain defendant's exhibits. Those exhibits which are joint shall not be repeated in the second or third divisions of the notebook. Each division shall be clearly and adequately designed, tabbed, and each exhibit appropriately labeled. The first page after each tab shall be a face page identifying the exhibit by number and type. The exhibit notebook shall also include an exhibit index. The party shall include in the notebook only those exhibits that are considered absolutely necessary. The failure to include a particular exhibit in the notebook, however, shall not preclude admission of any exhibit that was properly listed on the party's pretrial exhibit list. At the calendar call on November the 12th of 2025, the party shall submit to the court the index of the exhibits in the exhibit book. The index must be prepared on Form AO-187 with objections to exhibits indicated. Counsel shall each have a copy of the exhibit notebook and shall provide a copy to the court on the first day of trial. To the extent possible, the court will rule on all objections at that time. Following the court's rulings on motions in limine and objections to exhibits, counsel shall revise the exhibit notebook in accordance with the court's rulings. The revised exhibit notebook shall contain only those exhibits to which there is no objection. Subsequent to the court's ruling on any pending motions in limine, the parties shall submit A, an updated assessment of the estimated time required for the trial of this action, and B, a list indicating each witness who will testify at trial, a 1-sentence synopsis of the testimony, and in consultation with opposing counsel, the amount of time needed for direct and cross-examination. The court shall, in most cases, conduct a voir dire. Now, what is voir dire? It is a preliminary examination of a witness or a juror by a judge or counsel. So that's what that means. Okay, let's continue. At or before calendar call, each side may file and serve requested voir dire questions. The court will use the parties' proposed voir dire, plus have each member of the jury panel answer written biographical questions. Following this 2-part initial voir dire, each side may the court's discretion, have additional time per party to conduct supplemental voir dire. Counsel shall meet and prepare a concise, non-argumentative statement of the case to be read to the jury in connection with voir dire. The statement shall be filed with the court also at or before the calendar call. Now, here's the instructions regarding the use of depositions at trial. If deposition transcripts will be used at trial, the party shall comply with the following guidelines. At least 28 days in advance of trial, plaintiffs shall serve designations of any deposition transcripts it intends to use at trial. At least 21 days in advance of trial, defendants shall serve its counter designations together with any objections to plaintiff's designations. At least 14 days in advance of trial, plaintiff shall serve any rebuttal designations together with any objections to defendant's designations. At 7 in advance of trial, defendant shall serve any objections to plaintiff's rebuttal designations. By the calendar call, the party shall prepare and jointly file one transcript for each deposition to be used during trial. The parties shall edit the transcript using a mini transcript when available to remove all irrelevant, extraneous and unnecessary pages. Each portion of the testimony designated shall be bracketed to indicate beginning and end. A notice of filing setting forth each party's destination testimony by line and page and setting forth all objections shall be filed with the transcript. In addition to listing objections in the notice of filing, the objections shall be indicated in the margin of the transcript. The parties may either write their objections in the margins or use logical abbreviations that will be apparent to the court and other parties. For example, H for hearsay. If the parties use abbreviations, the notice of filing must include a key for the court's reference. A courtesy copy of the notice and transcript shall be delivered to chambers at the time of filing. Each party shall mark the courtesy copy of the transcript with a different color ink or highlighter to identify its designated portions of transcripts. Now, here go miscellaneous instructions. If the case is settled, counsel shall inform the court promptly by calling the judge chambers and filing a notice of settlement. In any event, such notices shall be provided no later than 10 a.m. the day before the first day of trial to give the court sufficient time to make changes to the calendar and counsel the summoning of jurors. In order to facilitate an accurate transcription of the trial proceeding by the court reporter no later than 5 days prior to the scheduled trial period, the parties shall file copies of 1, the witness and exhibit list, and 2, a designation of unique proper names, which may be raised at trial. Furthermore, no later than 5 days prior to the scheduled trial period, they shall deliver to the court reporter digital copies of all exhibits to be used at trial. Non-compliance with any provision of this order may subject an offending party to sanctions or dismissal. All dates established by prior court order remain in effect, except that to the extent any other provisions of this order conflict with a prior court order, this order controls. Done and ordered in Miami, Florida, this 29th day of September of 2025. As y'all can see there, this has been signed by the actual judge, Cecilia Altonaga. And that is the end of this court document. Now, what are your thoughts? The case is gearing up very, very quickly. We are going into October. We're like at the end of September. What are your thoughts? Hit the like button. It's free. Hit the share button. It's free. Hit the follow button. It's free. And again, I want to appreciate and I want to thank everybody who actually subscribe. Thank you for getting me past 500 subscribers. I really appreciate everybody who is a follower. Also, if y'all take a look at the top left-hand corner, that is my QR code. You can go to my Twitter and you can follow me there as well. Twitter will always see it first and then after YouTube. And again, I have a slew of other court cases that I'm also tracking and following. If you want to get down and divulge in other things, you can do that as well. And until then, as I always say, when you lead with integrity, you never have to worry about somebody questioning your loyalty or your intentions. And with that being said, I hope y'all have an amazing afternoon or wherever you are in the world, evening, and I'll talk to you soon. Take care.